All right, welcome everyone to our presentation on estate conservation and really estate planning. For those of you who are here, thank you so much for taking the time to be here. I'm going to do my best to survey and get into some of the most important details about this topic. And if you know anything about estate planning, you know it's a very complicated topic. So there's going to be plenty of stuff I'm not going to be able to get to. But with that, what I want to highlight here, first off, who I am. My name is Anthony Gerby. You can see kind of the pre-beard, post-beard me between the old picture and my current webcam, but also my contact information. I'm a financial advisor at Stein Financial Group. Here's our address. We're in St. Louis Park, Minnesota. This is our phone number, which will ring through to me. I'm extension 104. And if you just Google Stein Financial Group, or if you just Google my name, because as I'm aware, there's, I think, only 2 Anthony Gerbys in the entire world, and the other one lives in France. So if you Google Anthony Gerby, you're probably going to get me. That is a great way to get in touch with me. And I'm going to really encourage you to get in touch with us after we go through all this info, because I know that some of this information is going to touch you and your life in one way or another. It's too broad not to. So here's what we're going to do. We're going to provide some sound financial information. I'm going to help you identify maybe some of what your goals might be, or at least point out things where that'll make you say, ooh, I've never thought about that quite like that before. Let me call Anthony and see what he has to say about this specific issue to me. And we're also going to do consultations. We've already made the time for this, so I encourage you to take advantage of it. What does that mean? You get in touch with us. We'll also be following up with you with some of the materials from today, so you'll have a good reference point for what we've gone through. But don't wait, follow up with us. We've scheduled time for you to be able to meet with us and to get your specific questions answered, because you'll hear me say a lot, this is a general answer. The right answer is not a one-size-fits-all answer. That's where we need your specific situation before we can give you advice related to you. I moved out of the way so you could read the disclosures at the bottom. Important to note, I am not a lawyer. I'm a financial advisor. I work with lawyers a lot. We do a lot with trusts and estates. So I know a lot of these rules, but some of these things require lawyers, and I'll do my best to point those out. Another thing that I'll mention is if you need some of those services, maybe by an attorney. We have a lot of great people we like to work with, especially in the Twin Cities metro area, but also around the country. So if you are in need of some professional help as far as trusts, wills, your estate plan, we can help. If not us, we can point you in the right direction. So again, please don't hesitate to reach. Important question, but maybe a basic one. What is estate conservation and why is it important? So what is your estate? Maybe is a good first question. Well, it's your stuff, your assets. It's your personal assets, and that could be in an investment account, that could be in a bank account, it could be your house, it could be valuable items you own like jewelry or collectibles or things like that. Why is managing important? Well, I hope that's self-evident to a degree anyway, right? It's important to manage it because number one, those assets are in a lot of cases funding your retirement once you're done with your working life. And two, if there's anything left over, those things get distributed to your heirs. And we need to make sure that if that's something that's important to you, we're managing your assets in a way that allows for that transfer in the easiest and most efficient way possible, because there are a lot of pitfalls there. I will say there are 2 different flavors in my experience working with clients of estate conservation mindsets, we'll call it. First one is I call it the they should be so lucky mindset. And that is whether it's kids or a charity or whoever you want to pass assets to, the idea is, hey, this is my money and whoever gets it after me should be so lucky. And they can kind of deal with it when they get it. That's just fine. In fact, I love that mindset. Use the money that you earned for you. Fantastic. The other mindset is, I'm really concerned about passing on to this child or this person or that person. And I want to make sure there's something left over. Neither one is better or worse than the other. It's just 2 different types of people. But it's important, A, to know which one of those people you are, and B, depending on which one you are, kind of make a plan for what the future is going to look like. I will also mention, we're going to talk about this towards the end, but it is especially important, and I would write this down and circle it, especially important if you have someone in your family or someone who you would like to pass on any level of asset to, and it doesn't have to be an investment asset, could be a house, could be property, if they're set to inherit, and it's someone who has government assistance for special needs, and this is a very common issue these days, we need to make sure that your estate is set up in a way so that they retain their government benefits and inherit as much as possible. So we want you to be able to help them out, but we don't want to do it in a way that penalizes them in the eyes of the government, i.e., now they have too much money to get the assistance they were getting. I'll get into that a little bit later, but that is a huge underscore of everything we're going to talk about today. So let's jump into it. A couple famous examples. I'm from Minnesota. We easily could have thrown Prince on here to have as someone who had famous estate issues. But Aretha Franklin, for example, had no formal will or estate plan. Now, I could give you the full story here. Her 4 sons filed documents in Michigan and all listed themselves as interested parties, meaning they all wanted their own chunk of the estate. It was a mess. It could drag on for years in a case of dying without a will. We'll talk about that, what that looks like if that were to happen or happen to someone you know. Maybe you have, parents or someone else who's already passed on who was in that situation, and you know how complicated it can be to deal with. I could have used Prince for the next example, but Michael Jackson's on the slide. So Michael Jackson had a will, actually. It was all set up, but he had not transferred any of his assets into his trust upon his death. And there was a ton of litigation in his family, zeroing in on exactly what that meant for which assets go where. Now, of course, Aretha Franklin, Michael Jackson, they died with very large estates. So that makes it way more complicated. And whatever's large to you, it can still get that complicated. And I use these as kind of cautionary tales to say, this is why it's important to get a plan in place and stick to it. Because Michael Jackson had a plan. He just hadn't gotten all the way through it yet. So it's important to do both steps. Actually, the follow-up that we're going to send to you has a copy of Michael Jackson's will. It's not a very long document that you could read if you're curious about it, because it's all public record. We'll get to that too. All right, we're going to go through 4 different items today. And I'm going to tell you right now, 1 through 3 are about half of my presentation, and number 4 is the other half. And that's because trusts get incredibly complicated incredibly quickly. I'm going to do my best to be respectful of your time. I tend to be long-winded. So I'm going to do my best to keep this under 45 minutes to an hour, but 45 minutes is what I'm aiming at. So there's going to be stuff I'm going to have to go through a little bit more quickly than I would maybe if we were talking about that specific topic only. I'm doing it in the interest of time, but let me tell you, this is exactly the kind of thing, especially when we get to the trust section, that we should be having an individual conversation about. Because again, there's so many different options and it can get so complicated so quickly. Our workbook that we're actually going to send you has this little chart where you can break it down. A lot of people say, well, what is my estate? I kind of defined it a little bit earlier. Here's a good definition though, right? Your estate is your tangible assets. So that's physical, tangible meaning physical assets. Your investments, your cash, life insurance benefits that are set to pay out when you pay. So not just your cash value of your life insurance, but the actual death benefit of the life insurance is an estate asset. And then finally, you can get a sense of your net estate by, well, what do you still owe on your mortgage? Do you have any credit card debt? Are there any home equity loans or, other home line of credits at the bank that need to get paid off before your estate is fully settled? Don't forget, last expenses, funeral expenses are often a drain on an estate. So it pays to plan for all of that. So what are the benefits? I hope the benefits are somewhat obvious. Let me tell you a little bit about me. I'm an only child. I'm originally, by the way, we work in the Twin Cities in metro area. I'm originally from a small town called Little Falls, Minnesota. If you've heard of it, it's probably because Charles Lindbergh was also born there. I actually grew up about a mile from where his house was, although obviously he'd been gone for a long time before I was around. But I'm an only child, and my parents are also divorced. Both are still around, thankfully. But my dad, as at that time a single guy with one child, said, hey, he asked himself this question: what happens if something happens to me? And since my mom and him were divorced, she was not the beneficiary of his assets anymore. It would have all gone to me. And he said, when I was younger, he said, well, I should get something in place just in case that happens. I don't want a 10-year-old to inherit all of my assets at once, right? You don't know what kind of a kid a 10-year-old is going to be or what they're going to do with a bunch of money that comes into their pocket. So he set up this trust that was able to control how I would have received the asset should something have happened to him. Again, nothing happened to him, and he's still around, and that's great. And now I'm old enough where he said, I really don't think I need that trust anymore. I didn't know what kind of kid you'd turn out to be. I wanted to make sure you were protected from yourself in a lot of cases. But now, especially with what I do, he's like, well, you're pretty responsible with money. I don't have any problems just, having it be as simple as a transfer as possible. No middlemen, no trust or anything like that. Great. That's an example of how it can work, right? We can set up your estate to be managed after you're gone so that things flow according to your wishes. I could give you so many examples from people we work with. I won't give you all of them because we don't have that much time. But I will, besides the bullet points that are on this screen, which please go through: who will receive your assets? How will they get it? When will they get it? Who do you want to manage it? We have a lot of people we work with who maybe lean on one child versus another. And that's not always a great decision because it can seem like everybody gets along. And then once you're gone and there's money at stake, things can go south pretty quickly as far as relationships go. So we'll talk about that. How can we reduce settlement costs? Maybe can we reduce taxes or anything like that? If you have any minor children, it can be even more important. And again, a bullet point that's not on here that I really want you to think about: special needs. If a child or anyone set to inherit some of your money or that you'd like to be a benefactor for has special needs, we absolutely need to have a plan in place so that their benefits are not interrupted. Again, this is something that's close to me, so I highlight it, but I think it often goes overlooked, except for the people who are going through it day by day. Okay, so what are some of the challenges? Number one, finding a qualified attorney to do this for you, right? Here are some good ideas. You could ask for referrals. You could ask your friends. You could contact the local bar association. This is where we can really come in. We, Stein Financial Group, me personally, we know a lot of great attorneys, especially in the Twin Cities area, but again, around the country. So even if you're set, if you know someone who needs to get this set up and maybe the person you used is not an option anymore for whatever reason, get in touch with us. We're happy to provide those recommendations to you. It's part of what we do. We don't do the drafting and wills and trusts, but we work with a lot of great people who do. So that's what I'll say on that. Now, a scary word just popped up on the screen: probate. Probate is the boogeyman of estate planning, right? Everybody is scared of probate. And I'm here to tell you, this might be controversial, probate a lot of times is not as bad as you've heard. It can be annoying. It can be time consuming, but it's not always expensive or difficult. I say not always because we've all heard the stories, and they're true, of places where probate has gone horribly wrong. And what I mean by horribly wrong is, let's go back to that Aretha Franklin example. There are children of a parent who now passed who are physically incapable of agreeing on how to split things up. And again, my experience, because we've dealt with this in real life, it's often over the most trivial things. Who gets the lawnmower after mom and dad passed? Real story. We had children arguing over that. Thankfully not in my office, but I heard tell about it. We'll take each other to court potentially. And you may say, that not my kids or not my siblings, if you're thinking about your parents, or, this is not going to happen to me. The reason why we're talking today is that it could. And it's a scary thing to think about. It's not a fun thing to think about, but avoiding probate, which is possible, which is what the next couple sections are going to be about, is a key to a good estate plan. I'm not saying probate's always bad. You heard me kind of disclaim it right off the top, right? I said, actually, probate's not terrible for a lot of people, but it can be. So we still want to avoid it as much as possible, because then it's just easier. Otherwise, if we avoid probate, it's even easier than going through probate. So those are my 2 cents. Facts. Okay, probate can be expensive. Can be. Again, look at the can. It's not always, and I think there's been a lot of scare mongering around probate, where everybody says, no, it's the worst thing you could ever do. It's not always. That doesn't mean we still don't need a plan to make things as simple as possible, though. That's what I'd counter with. Probate can take a long time, especially with COVID, and getting a court date can be the most time-consuming thing of the whole process. Once you actually get it, it can go really smoothly. But actually getting into the court, that can be a problem. And this is why we can see Michael Jackson's will. In most states, probate is not private. You're going to get all of your stuff is going to be out there for anyone who wants to look it up. So just a couple things to consider here. Now, how would we go about, well, we'll talk about in a second about how we might go about avoiding probate or working around it. Estate taxes. This is also another thing that I think is a little bit overblown, possibly because the rules around it changed recently. So estate taxes are levied by the federal government and some states, depends on what state you're in, on any property that passes from someone who just passed to their beneficiary. It doesn't matter if you're family, except if you're a spouse. The spouse has special consideration. But even if you're a child, or you never met the person that just decided to give you a bunch of their money, okay, unlikely. But those rules would still be the same in those 2 cases. The step up in basis on inherited assets is an important consideration. So a step up, very briefly, I'll give you a quick example. Let's say mom and dad, mom worked for 3M for a long time, Minnesota company. I'll use that as an example. Developed or built up a lot of 3M stock over the years. Now, when she bought it, it was pennies versus what it's compared to now, the stock price, right? So when she passes it on to you as a child, again, this is the example I'm using, just a simple one. Let's say she bought it for a total of $50,000 and now it's worth $100,000. If she were to have sold it in her lifetime, she would pay taxes on that $50,000 in gains. But you, as a child, as a recipient, get a stepped up basis. So what the IRS says is, we're going to say, you've now inherited this 3M stock. We're going to give you the current balance as its original purchase price. In other words, in the IRS's eyes, you bought that stock at $100,000 and it's now worth $100,000, meaning you could sell all of it today and pay no taxes because there's no gain anymore. You could also keep that money potentially, depending on what type of account it's in, and there's a bunch of nuances there. But that's what a step up in cost basis is. It's a really powerful tool to transfer certain types of assets over generations, because you can limit taxes. Okay, there were a couple of changes made to estate tax law recently, going back to 2012, and especially the one in 2017. A lot of people don't know this, so this is one of those things that I would write down. Each person has a federal estate tax exclusion amount that for 2022 is over $12 million. So if you write estate tax, $12 million, that's what I'd write down. What does that mean? That means your estate, the first $12 million of your estate, that's everything. That's real estate, so your house, any other real estate you might own if you own any rental properties, tangible assets, what their value would be, and investment assets, savings account, checkings account, investment accounts, 401k, 403b, IRA, Roth IRA. Well, Roth IRA is a little different because that's actually tax-free. So bad example, but all of that stuff is potentially included in your estate, depending on how the contract's written. We'll get into that a little bit. The idea is you get the first 12 million of all of that summed up together estate tax free. You do not pay a penny in estate taxes. Only on your 12 million and first dollar, and actually it's a little bit over 12 million. So call it your $13 million. Do you pay taxes? And I'll give you the exact number here because I've got it written down. The exact number in 2022 is 12.06 million. So any dollar over that gets taxed at the estate level, which, by the way, was raised from 35 to 40%. But for me, a lot of the people we work with, and even in our financial advising practice, they're under that threshold. So estate tax maybe is a little less of a concern than it used to be. However, the very last bullet point on this slide, 2025, that number, that 12 million, is set to potentially cut in half. So back down to 6 or a little bit more, because it does get indexed for inflation. So we are going to talk about estate tax maybe more, because a lot of people, I think even the next slide says it, don't pay any estate tax anymore, because a lot of people aren't passing on 12 million plus. I mean, we're talking really top 1%. And if that's you, fantastic. And we need to figure out a way to get, the best tax bang for your buck. But just know that it's less common these days to pay it because the threshold is higher. However, in the future, the threshold might be lower. And then these strategies that I'm going to talk about are going to come back into play. So it's important to know that. So, you can worry about the American Taxpayer Relief Act of 2012, Tax Cuts and Jobs Act. That was the tax cuts that were passed under the previous administration back in 2017. They're automatically set to expire in 2025. Whether they get extended or not, we'll see when we get there. Yeah, I'm not betting on one way or the other when it comes to Congress. So how do federalists, I've already laid this out, but here's the actual equation. Your net value of your estate. Remember that little chart we looked at before where you calculated the net value of your estate? You take that minus the $12 million. What does that give you? Does that give you a positive number? If so, which means is your estate more than $12 million? That means that portion of your estate is taxable times your tax rate. That gives you your federal estate tax. Again, if this is you, I recommend we make a plan about it. And that's where one of our consultations could come into play, as well as potentially talk to an attorney and an accountant about the best ways to kind of mitigate that as much as possible anyway. So you may have heard about an annual and lifetime gift tax exclusion. So a lot of people ask, is there any way for me to give my kids money while I'm alive? And it doesn't have to be kids, by the way. That's just usually the situation we run into. And or shelter it from taxes in the future. And to an extent, there is. So number one, you are allowed, as of 2022, to give $16,000 per year to anyone as a federal gift tax-free gift. So if you give $16,000 to a child, they're not going to pay income taxes on it. It's not going to be federally taxed in that sense. Now, can you give more than that? Yes, you can. You can, but every dollar over $16,000 that you give will chip away at the 12.06 million that you have for your lifetime. So if you gave $17,000, that extra $1,000 would come off of your lifetime exemption. So let's use an extreme example. Let's say over the course of your life, you gave 12.059 million, right, to your kids. That means you can only give them $1,000 in your estate, or your estate can only be $1,000 or less that won't get taxed. So everything over $1,000, you've used up your exemption while you're alive. So it's a cumulative thing. It's an additive thing. You can use it up while you're alive. So it's important to keep that in mind, because it can make sense to gift it ahead of time. But just if you do that, you got to remember that whatever's left over probably is going to get taxed if you've gotten close to that $12 million number. If you haven't got close to the $12 million number, then great. It's not going to get taxed either way. So marital, I mentioned there was an exception for spouses here. Transfer of wealth is very simple, very simple. And this would be something I'd write down too, because this is the most common transfer of assets between spouses. Transfers of wealth between spouses are exempt. You notice I didn't give a dollar value there. Transfers of wealth between spouses are exempt from federal estate and gift taxes. Don't have to worry about it between spouses. So simple enough, I hope. Step up in basis versus carryover basis. Okay, I'm not going to spend a ton of time on this because it does get a little complicated, but I mentioned what a step up in basis is, right? If you hold appreciated assets like real estate until death, your basis, cost basis, is the record of what you bought that item for. So it could be stock, like in my 3M example. It could be your house. Hey, I bought my house for $100,000. It's worth $500 now. If that's the case, a step up in basis means that your inheritors, non-spouse, let's say your kids again, or anyone non-spouse, will get the step up, which means when they receive the asset, it's going to be like they bought it for $500, which is the current value. So they could turn around and sell it for no gain as far as taxes are concerned, which is important because then they don't have to pay that capital gains tax. However, carryover basis. What is a carryover basis? Excuse me. So a carryover basis is something that you've gifted to your child before you've passed. So I just talked about gift rules, right? If you leave your house in your will to your kids, then it's a step up. If you gift it to them before you pass away, then it's a carryover. And if it's a carryover, they don't get that increase in basis. So going back to the previous example, you bought the house for $100,000 and it's now worth $500. If they want to sell it, they're going to pay the $400,000 in capital gains. Or let me rephrase that. They're going to pay the capital gains rate times the $400,000. They're not going to pay $400,000 in taxes, but they're going to pay a chunk of the $400,000 in gains taxes. So important consideration there if you're thinking about gifting to kids, because I got to tell you, I hear the question all the time, just to take a brief interlude. Is there any way, and perfect slide to come up on, is there any way to avoid having the state drain all of my assets? Let's say I need a bunch of healthcare in retirement. You know, I've exhausted all my assets. Now they're going to make me sell my house to raise the money because I'm in a care facility or something like that. Can I just gift it to my kids and then it's all in their name so the government can't get at it for me? And the short answer is, well, you can, but it's more complicated than you might think. So number one, the government has a 5-year look back. So if you were to gift, let's say you gift your house and say, you know, I'm going into this care facility anyway, I'm going into assisted living or this apartment or whatever. I don't need the house anymore. I don't want to be forced to sell it should my care exhaust the rest of my assets. How do I protect it? I want to gift it to my kids. You can do that. You can do that. It'll go against your lifetime estate exemption, the 12.06 million, but you can do it. The downside is if you exhaust your assets or if the government looks at you within the next 5 years, because there's what's called a 5-year look back. That's what I'd write down, 5-year look back for healthcare. They can still make you access the asset, even if you gave it away 4.5 years ago. If you are in a need, if you're in a need of assistance, if you're going on Medicaid, for example, and that would be a whole nother conversation about healthcare. We have a lot of those on our YouTube channel if you want to watch them. But they can look back 5 years. So it can be a good strategy, but it's not always as effective as you might think. All right, we're on section 3. And I'm gonna pick up the pace a little bit because we've got a lot more information to get through. So our basic distribution techniques, intestacy. Okay, intestacy, it's going to get to that word in a second. That is a very fancy word. All it means is you've died without a will. So obviously the counter to dying in, well, they would call it dying intestate at that point, would be having a will. Or you could have jointly held property. By the way, common misconception, you can own joint property, whether it's an investment account or a house or anything tangible that's in some sort of contract. You can own it joint with someone who's not your spouse. I think a lot of people make that mistake. They think, well, I can only own joint with my spouse, right? No, you can own joint assets with a child, with someone who's not related to you at all. So something to keep in mind. There are pros and cons to that. Finally, contracts. When it says contracts, that would be like your investment accounts, like an IRA, a 401k, anything that's got a beneficiary written into it. Those are the most efficient, in my opinion, ways to transfer assets because it's written right into the contract. Who gets it? Doesn't go through probate. Very common misconception. If you have a 401k, or an IRA that you've set a beneficiary on, that account does not go through probate. Very important. All right. Problems with dying without a will. Okay, I think a lot of them are obvious, right? And number 3 is the big one, probate. Even though I said before, it's sometimes not as big of an issue as people make it out to be, it's still work to get it done. So dying without a will, I think, is the worst of those 4 options. It can be done. It happens all the time. Aretha Franklin, it happened to. But it's not something I would advise. I would definitely advise getting a plan in place. All right. What does a will allow you to do? What is a will? Maybe. Let's back up for a second. A will is a list of instructions that tells a judge. So remember, even with a will, a judge is involved here. How you would like your estate to be distributed. Excuse me. Estate is your assets. We talked about your net estate. It's all that stuff, tangible, investment assets, everything that's got a value to it. You can also name a guardian for your children, incredibly important there. And you can elect someone to manage your estate. I haven't used the word executor yet, but this is a good time for it. An executor is someone who executes your will. Little personal story. I'll get to this when we get to trust a little bit too, but from my own family again. My dad is one of 5. He's got 4 sisters, all still alive. And my grandmother passed away about 7 years ago now. She had, thankfully, and she lived a good long life, but she had some assets left over. Fantastic. You know, she was using them, but there was a little bit left over. So let's get those split up in the best way possible. My dad will tell you, and he's 100% right. He was incredibly lucky that my family on that side was really easy to work with. There were no disagreements. Everybody was on the same page about everything, and it was real simple to get everything done. There are a couple nuances with the trust. I'll get to that when we talk about trust, but it went so smoothly. I could tell you so many horror stories where it does not go smoothly. And if you don't have a will, you're almost asking for problems to come up. A will sets straight who does what, who gets what, so that it's written in ink, and they can't be mad at you. They have to be mad at, or excuse me, they can't be mad at each other, your heirs. They have to be mad at you or a piece of paper. And that's what I would recommend at this point, because you're gone at that point. I'd rather have them, if it's me, I'd rather have my kids be mad at me while I'm gone than mad at each other and kind of strain relationships. Another little idea I'll sprinkle in here, because this is what my family did. I thought it was really smart. 5 kids, remember. My dad and one of my aunts were the 2 executors of the estate, the dual executorship. They put a rule in where they said either one of them or both of them can be removed by majority vote. And remember, there's 5, so a majority would just have to be the other 3. So they said they did it because if the other 3 really had a problem with how things were running, they felt like the 2 executors were just kind of railroading everybody, which was not the case. But if that had come up, they could have voted to remove them. And I think that's a nice little tip. Not that you have to do it that way. That's just how my family ended up doing it. But it's smart to think about those pitfalls before they happen and kind of give us a few trapdoors. Again, my family was incredibly lucky that everybody got along. Not everybody's like that. So we've got estate documents. Let me give some definitions quick, and I will move on from this, but this is a thing I would absolutely write down, because you've heard all of these before. And if you're kind of like me, you're like, wait a minute, aren't those kind of all the same thing? No, they're all different. So let me give you the definition. A power of attorney gives a trusted individual the power and authority to act on your behalf. Here's the important part: in certain legal and financial matters. So when you think power of attorney, legal and financial, not healthcare, not healthcare. Also, what's the difference then between durable power of attorney and regular power of attorney? Durable means it stays in place even if the person they're acting on behalf of becomes disabled or incapacitated. Okay, a lot of people don't know that. They say, well, I've got my power of attorney in place, so if something happens to me, I go into a coma or something, I've got somebody who can act on my behalf legally and financially. No, you need a durable power of attorney if that's the case. And of course, there are contingencies for if that happens, but it may not be the person you want. Remember, you're picking the person if you're picking a power of attorney here. Now, a medical durable power of attorney, this one's maybe the most self-explanatory, thankfully. It outlines your preferences for forms of medical treatment and gives an individual, a person, the authority to make medical decisions for you if you're unable to make them for yourself. Now, a lot of people say, well, medical durable power of attorney. Well, that's power of attorney, which is the first bullet point, and durable power of attorney, which is the second one. And we just threw the word medical on top. So that must be all three combined. It's not. Medical durable power of attorney is only for medical decisions. They are not empowered to make financial or legal decisions for you. So if you want someone to do both of those things, you need to have them as both, most likely your durable power of attorney for financial and legal, and your medical durable power of attorney. They could also be separate people. They don't have to be the same. You could have 3 different people in all 3 of these different roles. So just something to consider. Finally, living will. It's different from a standard will in that it outlines which medical procedures you will allow in case of debilitating or chronic illness. Now, you may have dealt with this with maybe a parent or someone you know who's been in that stage of life, but the idea is if you don't want to designate a medical durable power of attorney, and you can have both, I'm not saying they're replacing each other, but you can also yourself lay out. And the most common one, of course, is, you know, you see it on other TV shows, a do not resuscitate, right? You get to choose how much medical care you want to be done on you should some accident or illness happen, right? And even if you're incapacitated, they follow the living will, not necessarily your next of kin. So you get to what happens to be what you want. All right, jointly held property. So joint tenancy or tenancy by the entirety or tenancy in common. First off, I'll tell you this. If you've never heard of tenancy by the entirety, if you've never heard of any of these, fine. I'm here to explain them. But I almost never work with tenancy by the entirety because it's not allowed in Minnesota, where I'm based out of. Now, we work with people all across the country. It is allowed, for example, in North Dakota. So every once in a while, you'll see it pop up, but it's pretty rare, except for those states that it's allowed in. But here's what they are. A joint tenancy means that you co-own something, an investment account, a savings account, a house, other property with someone else. When one of those 2 people dies, the other one just takes control of the ownership. Now, there are a couple different ways to divide it. You could say, well, we are joint tenants with rights of survivorship, which means if it's a husband and wife and they own an investment account, if the husband dies, the wife just takes over and now it's her account, 100%. There's also almost equity interests, you would call them, which could say if you own something tenanted common, you could say, hey, I own 50% of this rental property with my business partner. If I die, my wife maintains my 50%, or I split my percentage amongst multiple people, for example. Or if my partner dies, I don't inherit his 50%. He sends his 50% to someone else. So I will only max out at 50%. Again, this is for people who maybe want an easier path to distributing those assets, but whether it's right for you kind of depends on what assets you already have. So that, again, is where I'd say we really need to talk with you specifically. There's not going to be a one-size-fits-all. Dangers, right? Okay, a change in property could trigger gift tax consequence. A lot of people don't think about this. They say, wow, that actually sounds great. Let me put my kids as joint owners of my house so that when it passes, they don't have to go through probate. They'll just get my house because they'll already be owners on it. If you do that, it's considered a gift of the current value of your house to your kids because you're now giving them ownership. So remember, that's going to count against that $12.06 million. Not a reason not to do it necessarily, but something to consider. If the kids run into financial, again, I'm running with that example. You joint own a house with kids because you just want it to pass through to them more easily. If they run into financial difficulty, that house is now an asset of theirs. So even if you're living in it, it might have to be used to settle out their debts. So it's something that's another thing you want to keep in mind. And you have to share your tax benefits with the other joint owners. There's also something called community property. And under community property, and you see the states here, Wisconsin's the only one we really deal with. Most of those, I mean, we have clients that we work with in many of those other states, but Wisconsin being so close is the most common one. But under community property statutes, all property earned or acquired by either spouse during their marriage is owned in equal shares by each spouse. So it's a different way of looking at the marital split of property. And the essential principle is that any earnings and property acquired belong not only to the producer, but to the community of the married couple. So it's not my assets and her assets, for me and my wife, which in Minnesota, it is a little bit more that way. But in Wisconsin, if we were married, it would be our assets. Doesn't matter who earned them. Doesn't matter if I'm staying at home and she's the breadwinner out there, or vice versa. They're community assets at that point. Contracts. Okay, contracts is maybe a little bit of a tough word for this. I would prefer investment accounts, because it could also be pensions and life insurance and annuities. But what is important here? Any of these, and by the way, retirement plans, that would be IRAs, individual retirement plans, Roth IRAs, which are also individual retirement plans with a different tax structure, 401ks, 403bs, 457s. There's even more in that world. If you can write in a beneficiary to your account, and by the way, if you don't know, if you have an account and say, hey, I don't know if I have a beneficiary or if I can put a beneficiary on it, you should absolutely ask wherever that money is, or get in touch with us and we can probably tell you, depending on what type of account it is, whether you can put a beneficiary on. And if you can, I would recommend that you do 100% of the time, because it skips probate. It skips probate. You don't have to worry about probate. You just get to go through and distribute that asset according to how you want it to. Now, there's also, we're going to get to trusts here in a second, some nuances if you want a trust to inherit the asset, but you can still set that through the contract. So I highly encourage you to check your beneficiaries. If you don't have beneficiaries and you can, please do that ASAP. And if you don't and you can't, there might actually be a way that you can. So let me say that by saying we have a lot of people with accounts that maybe were set up in a way that don't allow for beneficiaries, but can be transferred into different accounts that can have beneficiaries, often at no fee or tax cost to you. Often, not always, so that's why we have to look at it, but it's something to consider. You may be able to get it into an account that has a beneficiary. All right, last thing on beneficiaries here is you'll see these primary, secondary, per stirpes, which is a Latin term, and per capita. Very simple. Primary beneficiary, something happens to you, that's who gets it. You can have 10 primary beneficiaries, and they could be 99% to the first one. A lot of places don't like to do half percentages. So 90% to the first one and 1% to each of the rest. I guess that would get you, you'd have to have 11 because that would only get you to 99%. But whatever, you can have as many as you want. Percentage can be whatever you want. It can be equal. It can be heavily weighted towards one, not the other, whatever you want. Secondary, or sometimes called contingent beneficiaries, important, only come into play if something happens to you and your primary beneficiaries, all of them, at the same time. Very important. So let me give you an example. You're a married couple and you've got 2 kids. I'll use me as an example. I'm a married man. I've got 2 kids. I've got an account that I want my wife to be the beneficiary on. Great. But unfortunately, my wife and I, something happens. We both pass away at the same time. My secondary beneficiaries, 2 kids. They would get 50-50 each part of that account then as secondary beneficiaries. Now, where does this per stirpes versus per capita come in? That would come in. Let's say I'm not married, but I do have 2 kids. So I've got 2 beneficiaries, no spouse to think about here. They're my 2 primaries. Let's say one of my kids predeceases me. And now if I've elected per stirpes on my beneficiary form, that means if they had any kids or if they had any beneficiaries, let's say I'm old enough to have grandkids at this point. It's hypothetical. I'm not that old yet, but if I was, then their kids, if I elected per stirpes, would get my first child, the one who passed, his share of the assets. If I elected per capita and one of my beneficiaries died, the remaining would get the entire account. So it's a way to make assets flow through I'll call it like this, a certain person's family tree. right? If I wanted my son and my other son to have 50-50, do I want my son's family tree, everybody after him, to get that 50%? Or do I just want it to go to whichever one of the two of them is still around? Well, again, something you talk about based on your particular family and your strategy. There's not going to be a one-size-fits-all answer. Okay, I'm going to do my best to get through some of the very complicated trust topics here in a way that's going to make some sense to you. And I'm going to start off, before I go through all of this, with another story going back to my dad's family here. So my grandma passes away. She has an IRA, individual retirement account. Important thing to know about IRAs, all the income that comes out of them, or all the money that comes out of them when they get distributed, is taxable, all of it. So she passed away. She set this IRA to go into a trust. Why would you do that? Why would you want your money to go into a trust? Well, the biggest reason, the number one with a bullet reason, control. You want to control how that asset is distributed to your heirs, to your family in a lot of cases, but it doesn't have to be your family. We'll talk about the different ways you can do that in a second. But so she set it to a trust. The downside of a trust, potentially, is trusts pay taxes just like people do, but their tax rates are different. And in the case of my dad's family, the tax rate was going to be higher than if any one of them had paid taxes on. So what we actually ended up doing was we said, hey, we got why this trust was set up. It was set up for control of the assets. My grandma obviously didn't know when she was going to die and said, well, if something happens to me sooner rather than later, this is how I want things set up. These are my instructions. She passed away when she was 92, and my dad and my aunts were all in their 50s and 60s. So they're all pretty responsible. And at that point, we were just trying to get at it with the least tax hit possible. So what we actually did was we actually passed the assets through to them individually so they could pay taxes. My point of bringing this story up is a trust is great for control, but there are some assets where you may not need a trust. So it's a balancing act between the things you want to control and the things you don't need to control. And that's, again, going to be totally personal to your family. So let's get into it. What is a trust? Oh, excuse me. A trust is a legal arrangement under which one person or institution controls property given by another person for the benefit of a third party. Okay, that sounds like a bunch of legalese. Let's do a little flow chart. Maybe that'll help a little bit. A grantor gives their assets to a trust, which is managed by a trustee. The trust then controls the assets that pay out to the beneficiaries. And I know the first question you're going to ask, which is, Anthony, can I be more than one of those people at the same time? And the answer is yes. You can be all three of those people. You can be the grantor, you can be the trustee, and you can be the beneficiary. So, you know, there's so much flexibility here. Or you could be the grantor, have a different trustee, and have completely separate beneficiaries. You can mix and match that however you want it to be. That's why it gets kind of complicated. Again, why would you do it? Why would you set up a trust? You do it for control, primarily. There are other benefits, tax benefits, we'll talk about that, deal with the estate tax and things like that. But you do it for control. Two types of trust. Testamentary trust. Well, think last will and testament. Takes effect upon your death, at which point it becomes irrevocable. There's also two types of trust. We'll get to them: revocable, irrevocable. They're exactly like what they sound. Irrevocable means once it's there, it's there. You're not taking it away. The revocable means you can change it or withdraw it at some point. The testamentary trust is created by your last will and testament. A living trust is created and funded while you're still alive. And this is the one that gets more complicated. Testamentary trust is kind of, you know, your basic trust here. So testamentary trust helps you notice that control is, the first bullet point in each of these. You control the distribution. It can help to reduce fees and taxes depending on how you set it up. And again, this is totally going to be individual to you. Testamentary trust does not avoid probate. That's why living trusts can be more popular in some cases, because they do avoid probate if properly structured. So revocable versus irrevocable. Okay, again, the difference is obvious, but let's get into some of the nuances, and I'll move so you can read that last bullet point here. Revocable trust, great for property management. it can be dissolved or amended at any time. And as a result, it generally does not have any direct tax benefits associated with it. The grantor, the person who provides the assets, can sell the assets, change the beneficiaries, change the terms and conditions of the trust. So one of the ways you can use this is for, you can set terms on which the beneficiaries can access the money. Say, my dad sets up a trust for me, like he had before. He would have had terms that I would not have received the full amount of his estate had he passed away until I was 25. He just set that in there. He said, well, I don't want you to be able to go out and buy a sports car at 17 if that's when something happens to me, right? So you can set rules. You can set as many or as intricate of rules as you want. You can make your beneficiary, and I hope this doesn't sound like a torture device, but you can make them apply when they need funds. If you feel like that you have a child who maybe is not good with money, or maybe would view this as a meal ticket versus a base upon which they can build their financial future, you can control their access to it. That's the number one reason. Again, I'm going to hammer that point to set one of these up. But with a revocable, you can change things, right? So one of the things that can't be held in a revocable trust are 401ks, IRAs. So that example I gave earlier can't be held in a revocable trust. An irrevocable trust, on the other hand, can't be modified or revoked. Irrevocable trusts provide the benefits of revocable trust along with the potential for estate tax savings. Let me go all the way back to the beginning. Estate tax only comes into play if your estate is over 12.06 million. So if that's the case for you, or if in the future the number is different, which it may be, that's when an irrevocable trust becomes even more valuable. We've seen a real uptick in revocable trusts based on the fact that most people aren't paying estate tax because most people aren't over the $12 million threshold. But if that's you, it opens up some more options to maybe reduce that tax. Special needs. This is one slide in this whole presentation, but I cannot emphasize how important it is. A special needs trust is a separate trust. It is set up for the benefit, so the beneficiary would be the person with special needs. And the key point is it distributes assets to them in a way that keeps them eligible for their federal aid, should they be receiving that. And that's, again, I hope it's coming across how important that is. I cannot tell you how important that is for families, for peace of mind for the person passing on the assets. They know that that child with special needs is going to be taken care of while also not being punished for maybe inheriting something. And also for that person themselves to know that, hey, I've got this working for me. It's all set up. I just have to follow what's been put in place. I don't have to work on managing it myself. So important. Incentive trust. I outlined this a little bit. This is where you can have certain milestones that must be hit before the money is awarded. And they don't have to just be age. You can say, hey, I've got a trust for this, and I've got a grandkid as a beneficiary. They have to complete at least 2 years of college, get their associate's degree before they get X amount of dollars. Or you could just say, no, they get it every 5 years. They get X amount of dollars. Or something else completely. You get to set the terms here. So advanced trust strategies. Okay, this is where it starts to get complicated. I'm going to go what's going to feel like way too quickly. I promise we will get into this individually if you get in touch with us. Please don't hesitate. An A, B, marital, and bypass trust. What is it? Okay. It's a revocable trust with an AB provision, enables both spouses to take advantage of the federal estate tax exclusion, allowing them to leave up to twice the applicable individual exclusion amount, 12.06 million, that's the amount I'm talking about, free of federal estate tax. So although some people think it's kind of no longer needed because married couples can take advantage of portability of the estate and all these different nuances, if you're married now under the tax rules, you get to double that estate tax rule. There are a couple cases where it does still make sense for this. So it enables you to pool your estate tax exemption. Irrevocable life insurance trust enables you to use life insurance to help provide funds for your heirs or pay taxes or other obligations on your estate that can't be avoided. You control where your life insurance proceeds go, in other words. And finally, a charitable trust, which there's a couple versions of these too, You can give to charity while also still benefiting yourself income-wise. I'll get to these. You might have heard of a charitable remainder trust. Okay, why consider an AB trust? It preserves your state tax exemptions, it shelters appreciation of assets, and it protects assets from creditors. It can also benefit children from a previous marriage. But again, I hope as you're getting this, they are popular, but they're less popular than they were because of the estate tax exemption that got raised in 2017. They may become more popular again in the future if those tax laws change. So I would say stay tuned for that. All right. Or life insurance trust. Okay, here's the simplest way to diagram. If you're going to buy a life insurance trust, you set up a trust. It's like a notepad there, right? You're writing a legal document. Inside that trust is a life insurance policy. That's the asset that you put in the trust. When that asset pays out, you don't pay estate taxes on it. So again, whether it's multiple life insurance policies or a very large life insurance policy, or maybe you just have a large estate outside of that life insurance policy that you don't want the life insurance to eat into that 12 million, it's a good way to shelter that from taxes potentially. Charitable and wealth replacement trusts. I'm going to go through all of these. Let me just read their names real quickly and then we'll get through them. And I promise we're wrapping up here. Charitable remainder trust, charitable remainder annuity trust, charitable remainder unit trust, charitable lead trust, and a wealth replacement trust. What are those? Okay, so a charitable remainder trust, you as the donor put property into the trust. The trust then pays you income based on that property. So I think property is a good example. Let's say you own a rental property that kicks off a certain amount of income every month. You put the property into the trust. You continue to take the income from the property. When you pass away, the property goes to a charity. So the lump sum, it doesn't have to be a tangible property. It can be an investment asset as well. But that property goes to the charity. So it's a way to benefit a charity while still reaping the rewards of that asset throughout your life. Again, let's say I think it's a good use of it is with a physical piece of property. Hey, we've got this land. We're not doing much with it. We found a way to rent it out. So we're going to be able to turn it into an income stream here, but we're not planning on selling it. The kids don't really have a good use for it. It's kind of just something we have and we want to take advantage of it. Well, use it as income and then potentially donate it to a trust at the end. And that can shield that part of your estate from taxes because it's going to a charity at the end, right? So then you don't pay taxes on that part. So let's say it was a piece of land that was bought for 10 grand and now it's worth $1 million, just to use the extreme example. And you're like, oh boy, this is gonna really hurt us as far as estate tax goes because that's gonna put us over the threshold. Donate it to charity if you don't need. Now, if you want it to keep it in the family, then maybe the best rule is to just pay the taxes. But I'm talking about ways to potentially avoid that. It can provide you income. You can receive fixed or variable income. There's no capital gains taxes on highly appreciated assets. That was that $10,000 to $1 million example. Contributions to trust are partially tax deductible. May help reduce future estate taxes, but it's irrevocable. Important. Once you do it, it's going to charity. You know, you're not deciding later that, oh, I made a mistake. I actually want to keep that land in the family, for example. Nope. It's once you put it in there, it's going to be gone when you die. So just know that it's important to be certain about it. All right. Charitable lead trust. Okay. It's kind of the opposite. You put the property into a trust. The income from that property goes to the charitable organization. So you donate the income from a gift while you retain the ownership of the property. So here's why it's a valuable thing. Money or income producing assets are placed in a charitable lead trust for a set number of years or for the life of the donor. The income generated is donated to the charitable organization, and upon termination of the trust, when you die, usually, the remaining assets are paid to the donor or donor's chosen beneficiaries, your kids, for example. This could reduce some of your estate taxes because some of the income has been paid out along the way. Not right for everybody. Again, just something to consider. Assets eventually return to beneficiaries, helps reduce or eliminate gift or estate taxes, provides a current gift to charity. So you do it while you're alive, which I always really encourage, by the way. Do those things while you're around to enjoy them. to enjoy, feeling the gift of giving. Because, when you're gone, it's great to give stuff away. That's fantastic, but you don't get to enjoy it. So I do encourage, if it's possible, to do that while you're still around. And again, donation is irrevocable. So we got to be sure about this. Okay. Now, this is our most complicated flow chart. We donate a wealth replacement trust. What happens? We donate property to a charitable trust. That charitable trust pays income back to us, remember, right? So the top half of this flow chart is what we already looked at. We already looked at a charitable remainder trust, right? That's exactly this graph right here, or this flow chart. That's the top. But what do you do with the income? Well, instead of just pocketing the income and spending it, what if we put that into a trust, another one, that bought a life insurance policy that then paid out to our kids, estate tax free? So you're using an asset to fund a life insurance policy that replaces the asset that's going to then go to charity when you die. Is this too complicated yet? Okay. If this is at all ringing a bell with you, saying, okay, that sounds interesting, Anthony, tell me more, we need to talk about it individually, because I could go on for another hour if we wanted to really get into the details on all of this. Here's a couple pro cons. Donate appreciated assets to charity, avoid their capital gains, you receive the income, and you can still provide your beneficiaries with a lump sum, which is the life insurance that you buy using the assets that you are then going to donate to charity. So it's a web of, and I think the presentation, the notes I'm using, literally use the term web of trusts, which sounds kind of nefarious, but is totally legit. It's done all the time, and we need to talk about if it's right for you. Here is a great slide to consider. Again, we're going to get you a lot of this information in a booklet, but I hope you've been taking notes. These are what I would take away. Charitable remainder trust, assets removed from estate, possible income tax deduction, potential reduction in estate tax liability. Charitable lead trust, you don't need the income from assets, but you want to retain ownership. So they're kind of two sides of the same coin, remainder and lead. And as you might expect, remainder remains. Actually, they really should have named it the opposite way, shouldn't they? A remainder, the property goes away. A lead, the property stays with you. What's really remaining or leaving is the income, but I won't get into the semantics there. Wealth replacement trust, that could be funding a life insurance policy within a trust. And again, you avoid the estate tax in that case. We need to, I'm wrapping up here, but we need to review your estate plan periodically. Tax laws change, and that can change what you need to do with your will, your trust, all of that stuff. The composition of your holdings may change. You may inherit something from a parent that now needs to be worked into your will or trust, right? So, and that's just one example. Your family situation could change. Again, we've worked with many people, without getting into specifics, who have, maybe they've got the one very responsible child. And they said, well, this person is going to be the one who's going to control our assets, and the other ones are going to have to go to them to ask for it. That can work, but I get nervous when I hear that, because I say, what a quick way to make them the bad guy of the family, right? If you give a person who's responsible, who should be in control of all this, control of the assets, that might be a recipe for some animosity. Let's put it into writing so that if the kids or whoever you're passing this to get mad, they get mad at a piece of paper, or they get mad at you who's not around anymore. And I don't want that, but I'd rather have that than have them get mad at their sibling, for example, who's now trying to manage their lifestyle while also gatekeeping on their siblings because, maybe they're not as responsible with money. That's why this is so incredibly important. There's a lot of different ways to do this. You can do it yourself. You can work with us, or you can procrastinate and not do it at all. And that's the thing I would recommend the absolute least, as you can imagine. All right, you've been so patient with me. Thank you so much for attending today. We have so many other great videos on our YouTube channel. I really hope you check those out and subscribe. And again, my name is Anthony Gervey. I'll have Taylor put my booking link in the chat one more time here. And I'd love, with the little bit of time we have left, to get to your questions. Again, so thankful for all of your time today.